Fabio Ruda.
Mr. Ruda, you are before the court on a felony complaint that alleges three counts. The complaint alleges that on or about September 3rd, 2025, at the location of 5301 Macaulay Drive, Superior Township, Washtenaw County, State of Michigan, count one is that you did carry a weapon concealed. Do you understand the nature of that charge, sir?
Yes, Your Honor.
That's a felony, punishable by up to 5 years incarceration, a $2,500 fine plus court costs, and does require the mandatory forfeiture of any pistols, weapons, or device. You understand that, sir?
Yes, Your Honor.
The count two alleges that on that same date and at that same location, that you did or were in possession of a firearm and that you are a person prohibited from possessing a firearm. Do you understand the nature of that charge?
Your Honor.
That's a felony, punished by up to 5 years incarceration, $5,000 fine plus court costs, mandatory forfeiture of the weapon or device. You understand that?
Your Honor.
Count three is the charge that on that same date and at that same location, that you did possess ammunition and that you are a prohibited person from possessing ammunition. You understand that charge, sir?
Your Honor.
That's a felony, punishable by up to 5 years incarceration, a $5,000 fine plus court costs, and mandatory forfeiture of the weapon or device. Do you understand all of that?
Right.
First question I have for you, sir, is do you want to be represented by counsel?
No.
Pardon?
Can you say it again? Ask me again.
Do you want to be represented by an attorney?
Yes, sir.
This is public defender.
Yes, Your Honor. Assistant Public Defender Nicholas Bukovich on behalf of Mr. Rueda. At the time, Your Honor, any mute as to the charges, and I'm prepared to address bond when appropriate.
Defendant, you waive any further formal reading.
Yes, I waive any formal reading. Thank you, Your Honor.
And defendant standing mute, court will enter not guilty to this charge. Probable cause conference in this matter will be set for April 9th. April 9th, 2026 at 9 a.m. All right.
All right, Your Honor.
As to bond in this case, anything from the people?
Yes, Judge, we'd asked to a no-go to the address that you had put on the record moments ago. We'd also ask for all standard bond conditions, including no assaultive behavior, stalking behavior, no firearms, ammo, components, or weapons, do not possess or use any devices for creating, manufacturing gun components, do not violate any criminal law, do not leave the state, no alcohol, marijuana, and drugs. And I don't know if he has any weapons currently, any firearms that need to be, that the court needs to know about, that need to be collected from this defendant, Judge.
No, Your Honor.
You don't have any weapons?
No. Well, you know, I'll be, no, I want to,
Mr.
We went over that, sir. So,
Rokovich, regarding bond.
yes, Your Honor. At this time, I'll be requesting a person with conscience bond. Mr. Rueda has been in constant communication with my office. We do have good contact info. He does have gainful employment. However, he has taken a break from that due to a injury with his ribs. However, he was working at a barber shop, but unfortunately, due to the accident he was in, he must take a break from work. He is a father and a primary caretaker to two children who are 5 and 4. He also helps take care of his mother, who is 76 years of age. He does have another pending matter before Judge Sway, which he is on a tether, but has no violations. He's been in compliance the whole time while in front of Judge Sway, and he'll be starting to work again soon. At this time, I would be asking for a person with conscience bond.
What's currently before Judge Slay?
Okay.
Well, let me ask this. How long has he been before Judge Slay?
You 1 second, and I apologize.
I've been on tether for like 4 months.
Yeah, he has been on tether for at least 4 months, is what he's indicating to me.
Was there a case pending in September of 2025?
Sorry, Your Honor.
No, it's okay.
From a note from my colleague in his final interview sheet, he thought he was arrested for both of these cases since December, spent some time in jail, and then this case was later authorized.
So both cases happened at the same time.
Yeah,
Okay.
I believe both cases happened around the same time.
My old case,
Yes.
my old case is like 4 years old, 3 years, 4 years old. The one I'm
The one that you
and Tether is like 3 or 4 years old.
Yes. So I think okay. My understanding then is his other case is a bit older, but he was arrested, but he thought was at the same time for these two offenses. So I do not believe he was on bond at the time of this new alleged offense. I think he was arraigned on the 2023 case closer to the September 2025 date.
so he wasn't on bond at the time of this case.
That is my understanding, Your Honor.
Did the people dispute that, or
Judge, I can't even locate the name because I don't even know the spelling, and I don't have a list of.
his last name is Rueda, Rueda, Senior. It's Javier is his first name.
Thank you, Judge. I'm looking it up right now.
Never.
And it's Rueda.
Rueda.
Okay, and what was the question, Judge? I'm sorry.
Was he on bond on his previous case time of this offense? This offense occurred September 3rd of 2025.
Case. No, I was when I came to the new case at the hospital,
That's what.
I was not in bond. I just they arrested me for the old case.
Yeah, that's what that did.
Got out of bond, and they charged me with a new case.
When you had,
4 weeks ago.
yeah, that's how I just explained to his honor.
So I was in the hospital when the new case happened.
But, sir, are you on parole, Mr. Allen?
No. No.
Were you on parole?
No. I was a long time ago, but I'm not. I ain't been on parole, probation, and then
I have here that the defendant was outside Trinity Hospital with a 3-year-old child, called and reported that the defendant was actually actively overdosing while sitting on a bench. The police, upon searching him after attending to him, found his parole ID card as well as 7.75 grams of suspected cocaine, as well as 20 rounds of ammunition. So it appears to me that not only was he in possession of firearm or weapon or ammunition at the time, but he was under the influence. At the time that this offense was occurred, he was on warrant status for that previous CCW in circuit court.
Yes,
For
Judge,
a-
that's what I just wanted to say. That's what my notes are showing as well.
Right. I'll order standard conditions, including no assaultive behavior, possession of any weapons or any stalking type of behavior. There's to be no alcohol, recreational marijuana, or any illegal drug. If he's on a tether on a circuit court, I'm not going to order a tether. I will indicate that the defendant is not to go to the 5301 Macaulay Drive address except for medical attention.
Yeah.
I'm just in the hospital or something. That's not believe me when I went back in there because I broke my ribs.
Yeah.
Oh, I can't work.
You can go for medical attention, is what you said.
Oh,
All right. I will, however, indicate that the defendant was on warrant status at the time that this was picked up. As further indicated, he was actively overdosing. So I think it's important to point out not only was he in possession of these firearms and ammunition, but
And there it is, the turning point. The judge is connecting all the dots: alleged firearm possession, ammunition, active overdose, and prior warrant status. In legal terms, this creates a narrative of heightened risk, which makes a personal recognizance bond far less likely. Notice how the judge carefully explains the reasoning before announcing the amount. That explanation matters because it shows the decision is based on specific risk factors, not emotion alone.
$5,000 cash or surety bond. So he'll need to post that prior to leaving. Go with my bail or something.
5,000.
5,000 cash or pardon? No.
Yes.
Hello, what's your name?
Hello, Diamond Buyers.
All right, ma'am, you are here before the court on an arraignment on two felony, they're both felonies, right? Yes, two felony complaints. First one, that being 26 FB 1025. That complaint alleges that on or about December 17, 2025, at the location of 3020 Washington Avenue, that you did knowingly retain, possess, or secrete a financial transaction device without the consent of the owner. Do you understand the nature of that charge, ma'am?
Yes.
That's a felony punishable by up to 4 years incarceration, a $5,000 fine plus court costs. You understand that?
Yes.
Is that a yes?
Yes, I'm sorry.
The other case, that being 126F 0190, alleges that on or about August 10th, 2025, at the location of 2723 Oak Valley Drive, Pittsfield Township, that on that date you did knowingly steal, retain, without the consent of the owner of a financial transaction device. Do you understand the nature of that charge?
Yes.
That's also a felony punishable by up to 4 years incarceration and or a $5,000 fine plus court cost. Do you understand that? First question I have for you on both of these matters: do you wish to be represented by the public defender? These are public defender cases. Go ahead, Mr. Buckner.
Yes, Your Honor. Assistant Public Defender Nick Buckovich on behalf of Ms. Byers in both matters. As it relates to a formal reading, we will waive any further formal reading in both matters. We'll be standing mute, and I'm prepared to address bond when appropriate.
Defendant able waive formal reading, standing mute. Court will enter a not guilty plea. I will set probable cause conferences in these matters for April 2nd, 2026, 9 a.m. Any issue regarding bond from the people?
Judge, I would just ask for a no-go to the 3020 Washtenaw Avenue address on the first case, and then the 2723 Oak Rally address on the second case. And then we would ask for all standard bond conditions, including no assaultive and stalking behavior, no firearms, ammo, or components, do not violate any criminal law, do not leave the state, no alcohol, marijuana, and drugs. Thank you, Judge.
Mr. Bekovich.
Yes, Your Honor. At this time, I'll be requesting a personal consent bond in both matters. Ms. Byers is currently a nursing student. She also does work full-time as a caregiver. She is local to the area, so she's not a flight risk. When she was made aware of these warrants by Mr. Drukas, who's representing her in another matter that'll be before Your Honor tomorrow, she came very quickly to take care of these matters. There's even a misdemeanor warrant that she's already paid the bond on, showing that she takes these matters very seriously and she's trying to resolve all her outstanding matters. So at this time, Your Honor, I would request a personal reconnaissance bond in both matters. I believe there be no issues of no contacts or no go-tos in any matter.
He wasn't on bond at the time of these offenses, for sure. See.
To my knowledge, no, she was not here.
You said she had something else before
From
on a warrant status when these occurred? I mean, because you said she has other cases.
Yeah, I had a misdemeanor warrant for retail fraud that I paid the $1,000 today for when I walked in, and then Edward said,
When did that warrant, you see it? I got that. What's the date of that? Yeah, well, the date of the warrant.
December 17th, 2021.
also was showing up for all my other court dates during that time. And,
yeah,
together.
yeah, my client has indicated that she has been paying to all of the other court dates at a time. That Mr. Drukas was doing this so we can consolidate all the cases and get everything on the same track.
Now this is an interesting contrast. Compare this to the earlier defendant, same courtroom, same judge, but a very different result. Here, the court is willing to grant a personal bond, which usually signals that the judge believes the defendant is likely to appear and does not pose the same immediate risk. It's a perfect example of how bond decisions are highly fact-specific. Two felony cases, yet two very different outcomes.
Anything else?
What do
on
you
the
think
people?
made the biggest difference here?
Set the defendant's bond in each of these cases at a $5,000 personal recognizance. In each case, I will order standard conditions, including no assaultive behavior, no possession of any weapons, ammunition, or anything fashioned to be a weapon. I will order also no alcohol, recreational marijuana, or illegal drug use. You understand all of that, ma'am?
Yes.
In the case ending in 1025, I will order you to have no contact with Ryan Coons. And you are not to go to 3020 Washtenaw Avenue. You understand that? In the other case, I will order that you're to have no contact with Renee Price, and you are not to go to the 2723 Oak Valley Drive address. You understand that, ma'am? All right. Thank you.
Thank you. So I still show up to court tomorrow? For good?
Yes.
Okay. All right. Thank you.
Well,
She has cases tomorrow.
I believe she has a PCC tomorrow. Yes. She wanted me
Hold on a
to.
second. I didn't understand what you were telling me. Come back up, ma'am.
No, they're yes.
You were trying to get them all together, correct?
Yes, if possible. I did speak to her. I did understand if you can't get them on the docket tomorrow with such short notice, and we did speak about that. Correct, Ms. Byers?
Correct. Yes.
I mean, I will set them. I mean, you guys are on these.
Yeah, and
So-
it's one of them we may have the conflict off of as well. Just by my
Have to.
quick review of the complaint, I recognize the co-defendant.
Got it.
I think it's the same by
Um,
Mr. Drukas is on all your other matters.
Yes.
How many are set for her tomorrow?
free your all insurances.
Okay, I'll tell you what, let me reset these tomorrow. Let's try to get everything together.
Yes, please.
So I'll set these for tomorrow, so she'll have all of those. And Mr. Bukovich, if we can try to get approval on the conflict and see if we can get that resolved so we can get her.
Yeah, as soon as I'm out here, Your Honor, I'll try to get it done for you today.
I know you will take care of it. So 326, I'll set your probable cause conference for then tomorrow on
Okay.
this case. It's
Great.
have all together. All right.
Okay, how you want it.
All right. Okay.
No problem. Have a good rest of your day.
Court does call the case. Zonaida Chaviera here. Chaviera, not present. I will, in each of these cases, then issue warrants for the defendant's failure to appear. Bond it will be set in the amount of $5,000. I'll give a 10% privilege. Those warrants will issue immediately. All right, I think that's all I have.
Yes, sir.
All right, that's it. Ms. Woods, thank you very much.
And then, Judge, I'm back at 1:30, correct, for the afternoon arraignments?
You're back
Or, I'm
at
sorry,
1:30?
1
You're
o'clock?
gonna come bother me at 1:32? No, I'm
Or,
kidding.
I'm sorry, at 1 o'clock, I mean.
At 1 o'clock, yes. We'll see you then.
Thank you.
And that wraps up today's
Thank
courtroom
you.
session. But what stands out most is how dramatically different bond outcomes can be based on the surrounding facts. One defendant faces cash surety because of weapons, narcotics, and warrant concerns, while another walks away on a personal bond after demonstrating cooperation and court compliance. That's the reality of bond hearings. Every detail matters. Let me know in the comments, did the judge get both decisions right, or would you have ruled differently?